Your next bill is House Bill 5090. It's an act relating to courts and civil procedure and particular actions, which is post-conviction remedy. It allows a person who has been convicted on the basis, in whole or in part, on scientific evidence that has been found or otherwise determined to be discredited by the scientific community, eligible to seek post-conviction relief on that ground. So with that, I leave it to you. Rep. Knight?
Very briefly, thank you, Madam Chair. So in our court system, there is occasionally there are cases that have scientific evidence, and that evidence is used to it's used against people. It can be also be used to exonerate people. It can be very, very powerful evidence. Juries like scientific evidence because it has a basis in fact. There is some scientific evidence that is well-founded, studied, proven. These days, the kind of creme de la creme is DNA evidence, which has a huge body of science behind it, and we can generally trust those results. But there is some science evidence that have been put forward, traditionally put forward by law enforcement agencies that do not stand up to the rigors of peer-reviewed, the scientific community and their systems used to validate results. And if you are a person who was convicted with some of that faulty evidence, and the classic type of evidence which would fall into this category is something like bite mark, sort of impression science, which is not proven, it's not validated, it's been rejected by a bunch of courts and the FBI and the federal government, the Department of Justice. This amendment to our post-conviction relief statute would give you another bite at the apple to say that I was convicted with science that isn't in fact science. It wasn't proven the way it's supposed to be proven under existing United States case law and the practices of the scientific community. And it would just give you another way, another avenue into post-conviction relief. It would ultimately make our criminal justice system more fair, provides a safety valve for people who have been convicted with faulty evidence.
Thank you, Representative.
Thank
you, Representative Knight. I think Chairman Corvace has a question.
Representative Knight, let me ask you a question. Would you consider on page, let's see, what page is this? Page 2 of your bill, where it says line 1, in whole or in part, would you consider changing that language to in large part? Let me explain why. I am not a lawyer, but I would imagine that there are a number of different aspects of a case that can convict an individual. There may be a propensity of evidence that would not rely on scientific evidence, witnesses, etc. So my concern would be the abuse of this if this were to go into law. If it was, when you say in part, if it was not a propensity, it was not a majority of the evidence that convicted it. You could tie up resources and tie up the court if a minority, let's say, of the case was considered, if a minority of the case of the evidence was scientific evidence that was refuted. Do you understand what I'm trying to say?
I do, and I would love to do that, but the problem is that would probably be unworkable, and here's why. And I'm sorry, the way I have this at home is when I speak, the image comes up on the screen and it fires back at me. So
you're talking about my image, my image firing back at you, because you're not the first person to say that, and it's usually not over video.
It's like this mirror thing going on. Anyway, in all seriousness, I would totally do that, and I would be in favor of that, but it would be unworkable because when we send the case to the jury, no one can go into the jury room and ask them, which piece of the case was most powerful? What piece of the case put you over the edge? We never know that. So if the bill is constructed in such a way so that if there is this scientific evidence anywhere within the body of evidence that the jury takes into consideration, then you can have a shot at the apple.
So if that's the case, so if that's the case, why use the phrase in whole or in part? If you can't use any fraction of it, because you don't know what fraction of it is being used in the grand jury, why even have that phrase there? Why not say that the conviction was based on scientific evidence?
Well, because we can't say that either. And I have an example to show you the difference. Recently, I had a case in my day job as a criminal defense lawyer where the only piece of evidence against the defendant was a fingerprint. And that defendant ended up pleading guilty, and it was, it is what it is. But had that case gone to trial, the jury would have been exposed to evidence that established there was a crime, and then there would have been this sole fingerprint which pointed towards the defendant. And let's say, for the sake of argument, the fingerprint evidence, isn't scientifically valid, whatnot, then what you're suggesting is, Representative, that might come, we might be able to swing with that to say if he's convicted with scientific evidence, because that's the kind of case where that's the only conclusion. But in the vast majority of cases where there is scientific evidence, it's part of a body. There might be some eyewitness testimony, there might be some forensic evidence of some kind, and then there might be some circumstantial evidence, and you just can't separate the two. I'm happy to fuss with the language as long as we get to the point where we can say if somebody is convicted and the body of evidence contained faulty scientific evidence, they have a shot at post-conviction relief. However you want to draft that, that's fine.
I think the problem with that is I think this is going to be, I'm sorry. My apologies, I didn't have the mic on. My problem with that is you're going to have a lot of people chasing, a lot of lawyers chasing this, and you're going to have a lot of abuse of the system.
Well, these days, right now, you can pursue post-conviction relief if you can say that somehow or another the conviction was obtained in violation of your constitutional rights. That is so much more wide open to the creative lawyer's work than this would be. And the system does a pretty good job of filtering out false or frivolous claims based on that. The system, I can just tell you, the system would not suffer any crushing load of cases with this amendment in place.
Thank you.
Representative Place.
Representative Knight, how are we doing tonight?
I'm good. How are you?
Good, thank you. Just the conversation with Representative Corvace or Chairman Corvace. When you talk about this makes the person just eligible to seek post-conviction relief. It doesn't mean it's going to be granted. They're still going to have to go through trial-like procedures, court procedures, and things like that to actually gain it. Is that correct?
That's correct. It just it opens up the door to post-conviction. But what happens? What a post-conviction case is really a civil case. It's you're suing the government because you've been wrongfully convicted, or that's the claim. So right now you can do it if you can point to some sort of constitutional violation, or there's been new evidence that you couldn't discover beforehand, and there's a couple others. This would just add one more door. You can open it, but the process of stepping through the door and getting to the other side is a whole different deal.
Thank you.
Any other questions? You all right, Doc?
I'm fine.
Thank you, Representative Knight. That concludes testimony on 5090.
I think Rep. Edwards is on the line.
Okay, so.
I'm right here.
No, he doesn't. I don't believe he does.
What?
Oh, the one I just did. Okay, we have to finish this one. 5090, I'm sorry, we're not concluded. We have two witnesses. We have Steve Brown from the ACLU. Are you with us, Steve? Randall first. Oh, Randall first. Randall Rose?
Members of the committee, or Madam Vice Chair, I am speaking in favor of 5090 and 5087. 5087, I think, is a complete no-brainer. It just requires. Sorry, let me shut off the echo. Okay, sorry about that. So 5087 should be a complete no-brainer. It just calls for annual reports on whether RIDOC is implementing a very major set of bills that were passed in 2017. Annual reports should be on something that major, should be totally uncontroversial. It's just a matter of making sure that the General Assembly's intent is fulfilled. On 5090, which is the post-conviction relief, I'm also in favor of it. Science develops a lot of good techniques to find culprits, but science also advances over time. Scientists realize that sometimes that things that they thought were well-founded were not, or in some cases, techniques are used in courts to secure convictions which have never even passed peer review. Scientists realize that part of the advance of science is that sometimes you have to revisit old scientific conclusions, and this bill just allows the justice system to keep up with the advance of science and to recognize that sometimes convictions have been obtained based on evidence that really no longer holds up to modern standards. And it's always a tragedy when somebody innocent is convicted. We should be keeping the courthouse doors open to make sure that when we realize that the basis for a conviction has been proved wrong or has been shown to be scientifically lacking, the relief is going to be available to an innocent person, to somebody who may have been convicted on insufficient evidence and may not have been guilty of the crime at all. And I would like to second Representative Knight's points about how it should be in whole or in part, because the fact is that even though what's presented as scientific evidence is occasionally not very well grounded in science, still that's very impressive in the courtroom when you have a prosecution in the courtroom and you can point to scientific evidence that says this person is definitely guilty, or there's only a 1 in 10 million chance that it's not the defendant who did this. That is very powerful, and in practice, triers of fact, juries or judges give a lot of deference to that. So when the scientific basis of that is undermined, it is important to have an avenue to revisit that, even if it was only part of what led to the conviction. In practice, scientific claims in court are given a lot of weight. So there is, if you read about cases where an innocent person is convicted, one thing that comes up fairly often is sometimes the court system doesn't like to vacate old convictions. They want to find some kind of basis for saying, yeah, we're still going to keep this person in prison. He probably still did it. There are some people in the court system who tend to go out of their way to maintain old convictions. So if the language in there only covered cases where the judge finds the dubious scientific evidence was a large part of the conviction, then that's an invitation to judges to say, no, I'm just going to uphold this old conviction because I find there's other evidence in the record that could have been the basis for the conviction too. Unfortunately, judges being inside the system are sometimes disposed to preserve whatever the system has already decided, so they may underestimate the weight that the scientific evidence actually played in the conviction. They may say that there's some other basis in the record for the conviction. I think it's important to recognize that in practice, scientific evidence has a huge weight in the courtroom, and therefore the wording of this bill is good as it stands. It's important to allow an avenue for a rehearing, even if the scientific evidence was only part of the basis of the conviction, because in practice that scientific evidence is going to have been given a lot of weight during the trial. So for those reasons, I'm in favor of the bill as it stands. Thank you.
Thank you, Randall. Next is Steve Brown from the ACLU. Do we have him on the phone? Hello, Steve. Are you there?
I am. Thank you, Vice Chair. I'm here on behalf of the ACLU to express our strong support for this legislation. You have written testimony. The only point I would emphasize from our written testimony is the enormity of this problem. We may not think of it as a big problem in terms of wrongful convictions, but it happens way too often. One of the things that I cite in our written testimony is a study that the Death Penalty Information Center did. It examined 34 death row exonerations, and almost a third of them of the wrongful convictions were the result of so-called junk science. So this is a serious problem. It happens all too often, and so we think that Representative Knight's bill is just a very simple but appropriate way of allowing individuals to seek the relief that they deserve when some of this junk science is used to create the potentially wrongful conviction. So we hope the committee will support the legislation.
Thank you, Steve. And there's one other person that was in support, and it's Mike DeLauro from the Public Defender's Office. So with that, that concludes testimony on 5090. It's a good bill, Representative Knight. I think it's time we put it into legislation. So with that, I'll turn it back over to Chairman Craven